comparison between ACP and CPG. Again, ACP is absolute community property, while CPG is conjugal partnership of gains. When does ACP commence? At the precise moment of the celebration of marriage. Article 88. When does conjugal partnership of gains commence? For marriages after the family code, the CPG becomes the property regime only if agreed to by the parties through a marriage settlement. What does it consist? So what is consisted by ACP? 1. All properties owned by the spouses at the time of the celebration of marriage or acquired thereafter. Article 91. 2. Under the ACP, the spouses cannot exclude specific properties from the regime unless done in settlement. 3. Winnings from gambling shall accrue to the community property, but obligations from gambling shall not. Article 95. Property acquired during marriage is presumed to have been obtained through joint efforts of the parties, even though one did not actually participate in the acquisition. This is true for a party whose efforts consisted in the care and maintenance of the family household. Such is regarded as contributions to the acquisition of common property by one who has no salary, income, work, or industry. The case of Ocampo versus Ocampo, 2015. What consists of the conjugal partnership of gains? 1. Proceeds, products, fruits, and income of their separate properties. 2. Everything acquired by them during marriage through their own efforts. 3. Everything acquired through their efforts by chance. What are the specific properties under the CPG? Article 117. 1. Acquired by onerous title during the marriage at the expense of the common fund. 2. Acquired through the labor, industry, work, or profession of either or both spouses. 3. Fruits from common property and net fruits for the exclusive property of each spouse. 4. Share of either spouse in hidden treasure, whether as finder or owner of the property where treasure was found. 5. Acquired through occupation such as fishing or hunting. 6. Livestock existing at the dissolution of partnership in excess of what is brought by either spouse to the marriage. And 7. Acquired by chance, such as winnings from gambling or betting. Moral damages arising from contract paid from the conjugal partnership of gains. From the case of Zulueta versus Pan American World Airways, 1976. Part kaya po ni sa what consist. Loans contracted during marriage are conjugal, and so is any property acquired therefrom. Mendoza versus Reyes, 1987. Property purchased by installment, paid partly by conjugal funds and partly with exclusive funds, if full ownership was vested during marriage. The CPG shall reimburse the owner spouse. Article 118. If a winning ticket is bought by conjugal funds, the price is conjugal. Otherwise, the price is exclusive property of the spouse who owns the ticket. Improvement on exclusive property. If original value is less than the new value, where the new value is equal to the value of the land plus the value of the improvements plus net change in value, then the land becomes conjugal. Again, if ang original value sa imong property is less than the new value, kibali mas dako ang new value kumpara sa original value, kay ang new value is value of the land plus value of the improvement plus net change in value, then mahimong conjugal ang property, subject to the reimbursement of the value of the property of the owner's spouse at the dissolution of the CPG. So if ma-dissolve na ang imong original value, mapulian, ma-reimburse when the CPG is dissolved. And then lastly, what constitute conjugal partnership of gain is property belonging to one spouse converted into another kind totally different in nature from its original form during marriage becomes conjugal in the absence of proof that the expenses of the conversion were exclusively from the account of the original spouse, subject to reimbursement of the value of the original property from the conjugal partnership. Mao ang what consists each of the property regimes. So let's go to what are exclusive. What remains exclusive under ACP and CPG. Let's go to ACP. What remains exclusive are 1. Properties acquired before the marriage for those with legitimate descendants of a former marriage to protect the rights of the child or children by a former marriage. 2. Properties acquired during the marriage by gratuitous title, that is, donations, inheritance by testate and intestate succession, including the fruits of such properties, except when expressly provided by the donor or testator that the property shall form part of ACP. Properties for personal use, that is, wearing apparel, toilet articles, or eyeglasses. Normal. Except luxury jewelry and those of special value that increase in value over time, partakes in the nature of an investment. So, mga nang exclusive under ACP. Let's go to what is exclusive under CPG. 1. Property brought into the marriage by each spouse as his or her own. So, that remains exclusive. 2. Properties acquired during the marriage by gratuitous title, that is, donation, inheritance by testate and intestate succession, but the fruits of such properties form part of the CPG, except when expressly provided by the donor or testator that the property shall form part of the CPG. Next, property acquired by right of redemption, by barter, or by exchange with property belonging to each spouse. 4. In Plata versus Yatco, 1964, Plata purchased the property when she was single. When married, she and her husband, Bergosa, co-signed the mortgage on the property. Upon foreclosure, Bergosa was sued for illegal detainer. A writ of execution on the property was carried out, but Plata refused to leave the premises. The Supreme Court ruled that Plata cannot be held in contempt. The property is not conjugal. Her husband, signing as co-mortgager, does not convert it to CPG. She could ignore the execution because the decision was for her husband alone. Let's go to the 5th one. Property purchased with exclusive money of either spouse. And lastly, number 6. Property purchased by installment, paid partly with conjugal funds and partly with exclusive funds if full ownership was vested before marriage under Article 18. Even if the installment is completed after the marriage, the property is exclusive if ownership was vested in one spouse before the marriage. What is the presumption under ACP? The presumption is that all properties acquired during the marriage form part of the absolute community property unless it be proven that they are excluded. The presumption under conjugal partnership of gains is that all property acquired during the marriage, whether made, contracted, or registered in the name of the spouse, are provided conjugal unless the contrary is proven. What are the charges and obligations of ACP and CPG? So, kani is shared between them, between ACP and CPG. Under Article 94 and Articles 121 to 123 of the Family Code, kani ang charges and obligations for both ACP and CPG. 1. Support of the following. A. Spouses. B. Common children. C. Legitimate children of previous marriage. And D. Illegitimate children. Following the provisions on support, common property is liable in case of absence or insufficiency of the exclusive property of the debtor's spouse, but the payment shall be considered as an advance on the share of the debtor's spouse. 2. Expenses to enable either spouse to commence or complete a professional, vocational course or activity for self-improvement. 3. Value donated or promised by both spouses in favor of common legitimate children for the exclusive purpose of commencing, completing a professional or vocational course or activity for self-improvement. And 4, generally all expenses incurred for the consent of the spouses or with the consent of the spouses or for the benefit of the family. So what is exclusively charged or obligated upon the ACP? If community property is insufficient, the spouses are solidarily liable for the unpaid balance from their separate properties except for 1. Donations contracted by either spouse before marriage which have not redounded to the benefit of the family. 2. Support of illegitimate children. And 3. Liabilities incurred by either spouse arising from crime or quasi-delict. Gambling losses of any kind that is illegal or legal shall be borne by the losing spouse's separate property. So what are the charges and obligations under charges and obligations that are exclusively under conjugal partnership of gains? If conjugal partnership property is insufficient, the spouses are solidarily liable for the unpaid balance of their separate properties. Gambling losses of any kind that is legal or illegal shall be borne by the losing spouse's separate property under Article 123. In DBP versus Adil, 1988, loan contracts signed by both spouses are conjugal, and they are jointly liable for payment even if one spouse signs a subsequent promissory note. In the case of Ayala Investment versus Ching, 1998, the Supreme Court ruled that the indirect benefits that might accrue to a husband in signing as a surety or guarantee in an agreement not in favor of the family but in favor of his employer are not benefits that can be considered as giving a direct advantage accruing to the family. Hence, the creditors cannot go against the conjugal partnership property in satisfying the obligation subject of the surety agreement. The contrary view would put in peril the conjugal partnership by allowing it to be given gratuitously, as in case of donation of conjugal partnership property, which is prohibited. Let's go to ownership. We're almost done. We can make it. We're gonna die if we don't make it, so fuck us. Let's fucking go to the next one. Ownership, administration, and enjoyment and disposition of property under both ACP and CPG. So what is common sa ila is that administration and enjoyment of the community or conjugal property shall belong to both spouses. So pwede ka maka-administer, maka-own, and enjoy and dispose of the property. In case of disagreement, the husband's decision will prevail, subject to recourse to the court by the wife for a proper remedy within 5 years from the date of contract. Okay, so what is... okay. Let's go to the others na shared nila. Donation of one spouse without the consent of the other is not allowed under Article 98. Except moderate donations to charity or on occasion of family rejoicing or distress. In Hader Manalo versus Kamaysa, 2002, mere awareness of a transaction is not consent. The case of Homeowners Savings and Loan Bank versus Dailo, 2005, in the absence of court authority or written consent of the other spouse, any disposition or encumbrance of the conjugal property shall be void. In the case of Cheeseman versus IAC, if however one of the spouses is an alien The Filipino spouse may encumber or dispose the property without the consent of the farmer. Kaya wala man kay right under the Constitution to own if you're an alien. The property is presumed to be owned exclusively by the Filipino spouse. So these are what parties in ACP and CPG can own, administer, and enjoy and dispose. Let's go to exclusively to ACP. Unsa ang ma-dispose niya? Either spouse may, through a will, dispose of his or her interest in the community property under Article 97. However, the will should refer only to his or her share in the community property. Let's go to CPG. What are ownership, administration, and enjoyment and disposition of property that is exclusive under CPG. In the case of De Ansaldo versus Sheriff of Manila, 1937, spouses are not co-owners in CPG during the marriage and cannot alienate the supposed one-half interest of each in the said properties. The interest of the spouses in CPG is only intuit or a mere expectancy and does not ripen into title until it appears after the dissolution and liquidation of the partnership that they are net assets. And lastly, disposition or encumbrance of conjugal property requires the following: authority of the court or written consent of the other spouse. The absence of such will render the encumbrance void. Article 124, paragraph 2. The solution of the regime. So, same sila og dissolution. The ECP and CPG can be terminated in the same way. It terminates upon, as stipulated in Articles 99 and 126 of the Family Code. 1. Death of either spouse. Follows rules in Article 103. 2. Legal separation, following the rules in Articles 63 and 64. And 3. Annulment or judicial declaration of nullity, following the rules in Articles 50 and 52. Judicial separation of property during the marriage follows rules in Articles 134 to 138. Rules on de facto separation. What happens to ACP and CPG if you are de facto separated? Generally, de facto separation does not affect ACP or CPG, except when 1. The spouse who leaves the conjugal home without just cause shall not be entitled to support. However, he or she is still required to support the other spouse and the family. 2. If consent is necessary for transaction, but is withheld or otherwise unobtainable, authorization may be obtained from the court. 3. Support for family will be taken from ECP or CPG. 4. If ACP or CPG is insufficient, spouses shall be solidarily liable. Moto ang rule. Let's go to the effects of de facto separation on both ACP and CPG. If it is necessary to administer or encumber separate property of the spouse who left, the spouse present may ask for judicial authority to do this. Anihawan ang spouse. And gusto sa present spouse nga i-administer, encumber ang separate property. Okay. He can do so if not judicial authority. If ACP or CPG is not enough, one spouse has no separate property, spouse who has property is liable for support, according to provisions on support. What are the rules on abandonment as applied on CPG or ACP? Abandonment under Article 101 and 128 of the Family Code. The present or aggrieved spouse may petition the court for 1. Receivership, 2. Judicial separation of property, and 3. Authority to be the sole administrator of the absolute community subject to precautionary conditions that the court may impose. The spouse or a spouse is deemed to have abandoned the other when he or she has left the conjugal dwelling without any intention of returning. Spouse is prima facie considered to have abandoned the other spouse, and the family if he has 1. Left for a period of 3 months, and 2. Failed to inform the other spouse of his or her whereabouts for a period of 3 months. Kani exclusive nga rule under CPG. In the case of Partosa Ho versus CA 1992, physical separation of the spouses coupled with the husband's refusal to give support to the wife suffice to constitute abandonment as a ground for action for judicial separation of their conjugal property. So, what is the liquidation of assets and liabilities under ACP and CPG? Last na ni on their differences. Liquidation. Procedure and the liquidation of assets and liabilities of ACP under Article 102 of the Family Code. 1. Prepare an inventory of the assets of ACP and of spouses with the market value. 2. The debts and obligations are paid with community property, and separate debts and obligations not charged to ACP paid by the respective assets of the spouses. A. If obligation exceeded the assets of ACP, nothing is divided. Creditors can go after the separate properties of the spouse which are solidarily liable for the deficiency. Okay, next. After sa debts and obligations nga unahon pagbayad by the community property. 3 is delivery of whatever remains of their exclusive property. 4. The balance or net remainder is divided equally between the spouses or in accordance to the proportion agreed upon in the marriage settlement, irrespective of how much each brought into the community. 5. If personal obligations of the spouse exceed his or her separate property, the creditor can go after the share of the spouse and the net remainder of the ACP without prejudice to the provisions of the law on forfeitures and delivery of presumptive legitimes. 6. If, covering all the community obligations and obligations of spouses, the balance of separate properties shall be delivered to respective spouses or their heirs, and they will also divide into 2 equal shares whatever is left of the community assets, without prejudice to the provisions of law on forfeitures and delivery of presumptive legitimes. 7. Presumptive legitimes are delivered to common children. 8. Conjugal dwelling goes to A. The spouse with whom majority of common children choose to remain. Children should be below 7 years of age, deemed to have chosen the mother based on the tender years presumption, and B. Whoever the court chooses in case of lack of majority. Let's go to liquidation of assets and liabilities under the CPG. What are the procedure? Number 1, prepare an inventory of all the properties. 2, amounts advanced by the CPG in payment of personal debts and obligations shall be credited to the CPG. So, bayaran nimo ang imong gi-advance. So, there should be reimbursement. 3. Reimburse each spouse for the use of his or her exclusive funds in the acquisition of the property. 4. The value of his or her exclusive property, the ownership of which has been vested by law and the conjugal partnership. So, if ikaw, or if ang imong spouse nahiutang sa other, bayaran nimo. Reimburse each spouse for the use of his or her exclusive funds. Imong bayaran ang spouse. Okay. 4. Debts and obligations of CPG shall be paid out of the conjugal assets, otherwise both spouses are solidarily liable with their exclusive property. 5. Remains of the exclusive property shall be delivered to respective owner spouses. 6. Indemnification for loss, deterioration of movables belonging to each spouse, even due to fortuitous event, used for the benefit of the family. 7. Not remainder of CPG shall constitute the profits, which shall be divided equally between the husband and wife, except when a different proportion or division was agreed upon in the marriage settlements. B. There shall be a voluntary waiver or forfeiture of such share as provided in the family code. C. Presumptive legitimes are delivered to the common children. And D. Conjugal dwelling goes to 1. The spouse with whom the majority of common children chose to remain. Those below 7 years of age is deemed to have chosen the mother based on the tender years presumption. And 2. Whoever the court chooses in case of lack of majority. So, ang say common nila when it comes to liquidation of assets and liabilities. The rules in case of termination of marriage by death of one of the spouses under Article 104 of the Family Code. 1. The community property shall be liquidated and the same proceeding for the settlement of the estate of the deceased spouse. 2. If no such judicial settlement proceeding is instituted, the surviving spouse shall liquidate the community property either judicially or extrajudicially within 1 year from the death of the deceased spouse. A. If no liquidation is made within the period of 1 year, any disposition or encumbrance involving community property of the terminated marriage shall be void. Kung wala liquidation within 1 year. Ang tanan ni mga gibaligya nga community property, ma-void siya. And B, non-compliance with liquidation proceedings would mean that a subsequent contracted marriage will follow a regime of complete separation of property. Kung maka-liquidation sa imong unang marriage, di man pwede isago lang inyong kuan kay gubot man kag kinabuhi. Matod pa nga attorney, there has to be housekeeping. Charot. And lastly, procedure for liquidation of properties for two marriages. 1. Determine the capital, fruits, and income of each community upon such proof as may be considered according to the rules of evidence. Capital. And then ang ikaduha ka duration. And 2. In case of doubt as to which community the existing properties belong, they shall be divided between two communities in proportion to the capital and duration of each. Thank you very much.